Um, all right, so good morning, everyone. My name is Russell Blair. I'm Director of Education and Communications at the State Freedom of Information Commission. It's great to be here, to be invited to do this presentation. A couple of things I always try to mention when I do this. We're going to cover a lot of material in a short amount of time, and that's just because, the way I think, try to do this is try to talk a little bit about everything. But if you guys have questions for the people on the Zoom, at the end, we'll have some time for questions, and then anybody in the room, just raise your hand if I could see everybody here. So if there's something I say and you need clarity or you have a question or anything like that, we can go through those in the room as we're going, and then we'll take some time at the end for either anybody online or at the room. The other thing I think is important for everyone to be aware, there's my contact information on the slide. It's also on our website. Please feel free to reach out. Don't view this as, this is our training and this is it, and after this, we're on our own. You've got certainly resources here with your law department, but you could also call the commission, and frequently I get calls from the law department, we talk about different things and try to figure out what the right thing to do is. So, it's not just today. If you need to reach out in the future, just give me a call, send me an email. I do this all day, every day. So things that you're not familiar with, I may have gotten a call that very day about it. So sometimes, I'm always happy to provide some clarity or answer a question or anything like that. For starters, I'd like to talk a little bit about the history of the Freedom of Information Act whenever I do one of these presentations, and just to kind of explain, what the law covers, how we have this law, a little bit of the background. So if you didn't know, the FOI law passed back in 1975. So this year, 2025, we're celebrating the 50th anniversary of the passage of the law. And really the impetus for the law was, really it was a post-Watergate reform. There was a lot of concern about government secrecy, secret meetings, records being destroyed. So across the country, there was the implementation of a lot of different good government laws, ethics laws, records laws. And in Connecticut, one of those was the Freedom of Information Act. Ella Grasso, you see on the screen there, she was governor at the time. She was a real champion of FOI in Connecticut. And really what it's about is it's about allowing the members of the public, the people of the city, the people of the state, essentially the people who are paying for government, right, the taxpayers. It's allowing them to understand the decisions that their government is making. And the law does that really in two ways, through providing access to public meetings and access to public records. And we'll talk about both of those today. We'll start with records and then we'll talk about meetings, but happy to take questions that anybody may have on either. So again, it's about transparency. It's about allowing the public to see the records that we have, to come to our public meetings, doing our discussions, making our government decisions in public. A couple of basics about the FOI law. There's two parts. We already touched on that. The Freedom of Information Commission, which was also created with the passage of the law. Basically, what we do is we settle disputes that arise where a citizen believes that a public agency is not following the law correctly. That could be a board or commission. Maybe there was a concern about a meeting, an agenda wasn't posted, the minutes weren't filed, or it could be that there's a concern about a records request. They've requested documents from a city department, and they got things back and they think stuff was withheld, or there were redactions that they don't think were proper. Maybe their request was denied entirely and they don't think that that the law should prohibit disclosure of those records. So any sort of concern that people have about freedom of information, they can file a complaint with our commission, and we have the ability to investigate those complaints. We can hold hearings, we can bring witnesses in, really to try to figure out, what happened and if there was a violation or not. And then if we do find a violation, we have some different remedies that we can, we can affect. We can order the production of records. So if there was a case where, there was a department in Norwalk and they said, well, we don't think those records are, publicly available, and the commission looked at it, we might say, well, actually, maybe some of them are, and, we would issue a very specific decision, sometimes even down to like the lines of what needs to be given out versus what can be withheld. We can also, in terms of meetings, we can nullify votes taken at a meeting. We don't do that all that often, but I say that as a word of caution. Why is it important to do this correctly? Well, if you don't, and somebody brings a complaint to the commission about a meeting, they could say, hey, I would like the commission to nullify that vote because, no agenda was posted for a meeting or something like that. We can order training. So I jokingly say it's always nice to be invited. I'm not here because things went wrong. So you guys are trying to get ahead of the ball. And we can also issue fines too. We don't do that too often, but we have the ability to issue fines. What is a public agency? I've already said this a couple of times, probably. A public agency or agency is really just what the law refers to as anybody who's covered by FOI. So if we think of the city of Norwalk, it's all your various departments, all your boards, your commissions, your committees. The mayor's office is a public agency. The law department is a public agency. School districts are public agencies. I think one important thing to understand in terms of FOI is that really every public agency is responsible for their own records requests. Now, that doesn't mean that you might not coordinate things across the city, but really what it means is if somebody wants to get information from a certain department, they need to go to the people that have those records. The mayor's office, for example, is not responsible for FOI requests for the police department. So that's just something to keep in mind. It's important that you understand the records that your department has, the exemptions that apply to your records, because, ideally, and I think it works better when the work is spread out a little bit. And one thing I should mention too, sometimes people get concerned with FOI, it's a law, maybe you're not an attorney. I'm not an attorney either. My background is in journalism. That's where I come from in terms of knowing about access to records and meetings and all that. So while you may not be an attorney, I think you don't have to be an attorney to understand FOI. It's important that you understand, the records and the exemptions that deal with the department that you work in. And so we'll talk about some of those specifically. And again, if people have questions, maybe something that's come up in your office, I'm happy to to address those. There are some times when like a nonprofit might be covered by FOI, but it's really the exception rather than the rule. Generally, FOI, applies to all government entities. So as I said, we'll start with, public records and records requests. And what I find helpful is when we talk about FOI, so everybody understands, what is a public record? What you see on the screen now, this is the definition of a public record straight from the Freedom of Information Act. I'm not going to read the whole thing because you see it up there on the screen, but there is one passage I think is really important. Recorded data or information relating to the conduct of the public's business. That is what determines if something is a public record. Does it relate to the conduct of the public's business? So any records that deal with, Norwalk city business, what the various departments are doing, expenditures of taxpayer money, correspondence among city officials, correspondence that the city has received, personnel records of city employees. There's a huge amount of public records, but the key thing is that it relates to the conduct of the public's business, and that is interpreted pretty broadly. So essentially, if it deals with city business, it is probably going to be a public record. One thing that is important to mention is in that definition there, you don't see anything about a device. It doesn't say anything, oh, and by the way, the records have to exist on a government-owned device, and that is because the device doesn't matter. So what that means is that you can create public records, you can have public records, on your own personal cell phone. This is my personal cell phone. The state doesn't give me a cell phone. If I am texting people at work about work matters, those text messages are public records. Somebody could request my text messages. If the police chief and the mayor are texting, whether those are city phones or not, those are still public records. So it's something to keep in mind. It doesn't mean that we can't use our own devices for city business. Most city employees probably don't have a city phone. So if you need to use your own phone for city things, sending an email or texting or those sorts of things, that's okay. There's nothing wrong with that in terms of FOI. But just keep in mind whether it's your own phone, whether it's, maybe you use a Gmail account, for some things instead of your city account, the personal versus private of the device or the account, that doesn't matter. What matters is the content of the message. If you're texting your colleague about your kid's softball game, that is not a public record because it's not really dealing with city business. Just because you're both city employees, the content of the records is what's really, really important. And the way that the FOI law works is basically if it deals with the public's business, it is a public record. But this second paragraph on the screen is also really important. Except as otherwise provided by any federal law or state statute, all records kept on file are public records, and everybody has the right to inspect or copy public records. But what that means, except as otherwise provided by any federal law or state statute, it means that if there is another law that says something is confidential, is exempt, cannot be disclosed, sometimes it'll say that it's available, for a limited number of people. Maybe, certain people can get access, others can't. But if there's another law, whether it's in the if there's sections in the FOI Act that deal with exemptions, but if there's anything contrary to disclosure, that'll always override the disclosure requirement in the Freedom of Information Act. The hard part with FOI is that there's a list of exemptions in the law, and we'll talk about those, and some of those you may be familiar with, things like attorney-client privilege and preliminary drafts and personnel files. But these are not all in one section in the statutes. They're all throughout. A lot of times what will happen is when the legislature is creating a program, somebody will say, hey, we're putting this new program together. There's some data we're collecting and we're thinking, maybe some of this should not be exempt. So when they create the program, there might be, 2 lines in some statute about, this public health program that says, oh, and by the way, these investigations are confidential or something like that. So if you ever find any statutory references that say confidential, cannot be disclosed, then those are not records that are available under FOI. They are still public records, but because there's another federal law or state statute, they can't be provided. One example I like to give is if anybody has a driver's license, when you go, they take your picture. So the state has got all these photographs of everyone that has a driver's license. Those are public records. They're not available under FOI because there's a motor vehicle statute that governs disclosure of those records. They can really only be used for by certain people for certain purposes. And I think with that one, there's even a penalty if somebody who worked at DMV was disclosing those to other people that weren't allowed to have them. So depending on the record, there could be an exemption that would say it's not generally available. Okay, so an overview of some of the different aspects of the public records part of FOI. The last bullet point there, I'm going to start with that one. Agencies do not have to answer questions, do research, or create records that don't already exist. I think this is really important to know because I think for you all working for the city to understand the limitations of the FOI law. I think members of the public sometimes think, this law means I can ask you to pretty much do anything and you've got to do it for me. I want you to create a custom report. I want you to give me an Excel sheet and I want column 1 to be this and column 2 to be this and column 3 to be this. That is not what the FOI law is about. The FOI law is about if you have a record, somebody can request a copy of it, and unless there is an exemption, you give them the copy of that record, or they can come in and they can inspect records in person. So you don't have to, reformat things. You don't have to, like I was talking about, create an Excel sheet with the certain categories that the people want. If you have an Excel sheet that you ran for a report, you can give them that. If it doesn't have all the information they want, they may have to go do their own research or consult other records or create whatever document it is that they want. Another way that this comes up a lot is you may get a request and somebody will say, give me a list. I want a list of, every property that has this certain concern. I want a list of all these things or whatever it is. If you don't have that list, you don't necessarily have to go and create that list under FOI. It may be that you give somebody a bunch of different records and they've got to go through those records and they've got to pull out, whatever the information is that they need. To give an example, there was a call I got from a police department, and I guess maybe business was slow in the personal injury law field in the city because they had gotten a call from a law firm. We want a list of everybody who's been in a motor vehicle accident in your city in the last 6 months, presumably try to, generate some new business. That is not a list that most police departments keep. They don't come back and write the name on the big list of everyone who's been in an accident. They have accident reports. So somebody can request accident reports and they could go through accident reports and they could try to find the people that were involved and call them and say, hey, do you need an attorney? The law doesn't really take into account why somebody wants the information. I think that's important to know. You could ask them if you're curious or if you think it'll help you to understand the request or fulfill it. But if they tell you, no, I'm not going to tell you why I want it, that doesn't matter. So in this case, a law firm can make an FOI to try to find new clients, but the police department doesn't have to create the list for them. They can give them accident reports and they can try to find those people on their own if they want to. And the same thing goes for answering questions. FOI is a request for records. If somebody is asking you questions, generally, I think most people that work in municipal government are going to try to help somebody if they have questions if they live in the city. But if you don't know the answers, you can't answer the question, you've already answered it, and you feel like, look, that's it, that's all I can tell you about this. That is not the grounds for an FOI complaint. An FOI complaint is if you deny them a request for records. So if you have records, you have to provide them unless they're exempt. If you don't know the answer to a question, you could tell somebody, I don't know the answer. I can't answer that. You could say, hey, I already answered that. And that's all we can say on this. So the law is not about asking questions, it's about, records, and that's an important distinction. Sometimes the public doesn't always understand that. So a couple other things. There's no requirement that somebody use a specific form to make an FOI request. So if somebody sends an email asking for copies of public records, that under the law is an FOI request. They don't have to say FOI. They don't have to cite a statute. They don't have to do anything other than, they could send an email to a town department. Hey, I want all the invoices for this project from the last month. That's a records request. It's as simple as that. Now, it doesn't mean you can't have a form or you can't have an online system. You can have preferred ways, and you could certainly point people to those directions or have a thing on your website that says, hey, send it to this email or use this system. That can be very helpful to manage and keep track of things. But if you just get a letter in the mail, that's an FOI request. So you can't reject somebody's request because it wasn't on your preferred form or it didn't come through your online system or something like that. So next, we'll talk a little bit about fees. So with records inspections, you probably don't see this all that often anymore. It's much more common that you'll get, probably an emailed request, and probably asking for electronic copies of records. Can you email me this? Can you email me that? But people can't come in person if they want to. Maybe it's a particularly large file, or sometimes people want to see what's there before they decide if they need copies or not. Somebody is interested in buying a home. They want to come into City Hall and they want to look in the building department and go through the file and see what permits and those sorts of things are in there. They could do that. So they can make a request to inspect records. There's no charge to come in and inspect records. You only charge people for the copies of records that they want. So I'll start with paper copies because that's simpler, and then I'll talk about electronic records. So for paper copies, keep in mind if a record exists in paper form only, you don't have to digitize it. So if somebody is coming in and they want plans or something, and those plans are hard copy paper and they were not scanned in, then you can make paper copies of those records. And for photocopies, it's 50 cents a page. For cities and towns, that's what you can charge. If it's like a map or a bigger reproduction, basically you can charge what the cost is to the city. So if you have to set, let's say those plans are big, you have to send it out to get a copy, or maybe you can do it yourself, but it's more expensive because the paper or whatever it might be, so maybe a map is $2 or something like that. But generally, 8.5 by 11, 50 cents a page. If the cost of a request is going to exceed $10, you're allowed to ask for prepayment. So if somebody is asking, the guy in the building department looks through the file and says, yeah, you know what, I want a copy of the whole file, and it's 200 pages. Before you go make the copies, you could say, hey, that's 200 pages of paper here. It's not available digitally. It's 50 cents a page. It's $100, and you could ask for prepayment because the cost exceeds $10. So electronic records is a little bit different. There is a provision in the law about scanning records. So if somebody comes in and they want to, again, let's use the building department example. He doesn't want a copy of the whole file, but he wants to make his own copies. The law right now doesn't explicitly allow someone to use a cell phone. A lot of towns and cities will say, look, it says portable scanner, but we're going to let you use a cell phone because it's the 21st century. We're actually trying to get the law changed to put cell phone in there. So, that $20 fee is basically, the time that the person is there. So if I want to make my own copy of my building file, I can go in to the building department, I can pay $20, and then, the city could say, we'll let you take pictures with your cell phone, we'll let you use a portable scanner to do that. But if somebody's asking for electronic records and they're asking for them to be delivered electronically, there's no charge associated with that, really, except in special circumstances. I'm not going to get too deep into it, but what the law refers to is something called programming and formatting. And basically the way I try to explain it in layman's terms is if it's something that is requiring some kind of extraordinary IT expertise, most systems today, I think, are pretty user-friendly so that, the people that are operating them, your registrar of voters can get voter information from the system. They're not having to call the IT people to come and program it in a certain way. So it was really something, I think, with the early days of computers where it allowed you to charge for some of that expertise. So there could still be some circumstances, probably not as many as there used to be, but generally you can't charge for electronic records that you have electronically that you're going to email to somebody. You could charge for a USB drive or a DVD. Somebody wants a large volume of records, you put it on a USB drive, you could charge them the cost of the USB drive. Somebody wants body camera video and you want to put it, you put it on a DVD for them, you could charge them the cost of the DVD. But generally, if it's electronic, a PDF, it's emails that people are asking for, and you're sending them to those, via email, there's not really going to be a charge for that. And across the board with FOI, and this is a frustration in a lot of municipalities, but it's the same rules that everybody has to play by. You can't charge for the time. So it's not like you could say, well, it took our secretary 5 hours to do this FOI request. She makes $24 an hour, so we're going to charge you, 5 times her hourly rate because she was the one that did this. So, again, electronic records, if it's available electronically, generally not a charge, and across the board, there's really not a charge, for time. So, these are the fees that are available. I always tell people, charge the applicable fees because, again, you can't recoup the time, the hourly salary of the person. But, you can charge the fees. You can ask for the prepayment. The prepayment, that could be very useful, especially to avoid having somebody make a large request and then not come pick it up when they learn what the cost is, which is very frustrating. It's one of the things that I hate the most when I hear that, because you have, people who are doing everything that they're supposed to be, and then the requester can't be bothered to pay the pretty nominal fees that are outlined in the law. So I think charge the prepayment, be upfront with the fees, so that there isn't an issue later on. And then they say, oh God, I didn't know it was going to be that much. You never told me. Or they stop picking up the phone when you tell them it's time to pay the bill. Any questions on anything so far? I know we've been going a little bit, so just make sure. Okay. All right. So this next slide, probably the #1 question that I get from both the public and also from towns and cities. How long do we have to fulfill these requests, right? What does the law say about this? Well, there's one specific timeline in the law that you want to be aware of, and that is if you get an FOI request, if you receive an FOI request, you have to acknowledge receipt within 4 business days. Now, why is that important? Well, what the law says is if you do not, if the requester does not get a response within 4 business days, that is considered to be a denial. So even if you don't intend to deny them, if you don't respond to them, they have no way of knowing that you got the request. For all they know, you deleted it, you put it in the trash, whatever. So the first thing you want to do if you get an FOI request in is make sure somebody responds on behalf of the city just to confirm receipt, and that happens within 4 business days. A couple of things I will say about that is, to step back for a second, the law sets out what we have to do, but how you do it is really kind of up to you. So like even with the acknowledgement of the records request, it doesn't necessarily have to be the person who received it. It could be that you have somebody in your city who's kind of handling this and shepherding these things, and that might be the person who sends the letter. Or in some small towns, it'll be the first selectman's assistant, or the first selectman himself or herself might send the response back. So it doesn't matter who from the city responds, but somebody needs to respond. And people have asked me, well, what happens if we're what if we're on vacation for 2 weeks and somebody emails us an FOI request and, we get back from vacation 2 weeks and that's the first time that we see it? Well, I think if a case like that went to a hearing, we would have to get into, okay, well, when did you actually see the email and all that kind of stuff? But I think a way to avoid any issues with that, any complaints maybe where, you really never saw the request, is to put an out of office email. I think that's good for a lot of reasons, but particularly with FOI, if you're going to be gone for an extended period, put something in your Outlook that says, hey, I'm out of the office, contact, somebody else. Because then even if they send it to you, they'll get the bounce back and they'll say, okay, we understand the person's not there, and they might contact somebody else. But if they don't get any response, they don't have to reach back out to you. They could just file a complaint. And there are people who will make a request, they'll wait a week. If they don't hear anything, they just think they're getting ignored and they'll file a complaint, particularly if they really urgently need the records, because they may think, hey, I'm not going to wait around for a month to even figure out if they've gotten it. So the acknowledgement is really important. And then sort of overall globally, what is the response time? Well, we have to fulfill records requests promptly. And what does that mean? There is not a specific time period in the law. Sometimes I think it would be easier if it said 15 days or 30 days or 60 days or whatever, because then we would know, all right, we have got this much time to get it done. But I think the legislature was smart because promptly it's meant to be flexible. And it's also meant to take into account really kind of ideally a balance of the needs of the requester with the obligations and responsibility of the city to get through, not just FOI requests, but all the other things that you all have to do in your day-to-day work. So the way the commission looks at this issue of promptness, if somebody made a request of Norwalk and they filed a complaint and they said, hey, I don't think Norwalk is being prompt, and we had a hearing where it says, consider, these are the things the hearing officer, one of our attorneys, will be asking you about. How large was the request? About how many kind of man hours do you think it would take to get this done? And then we would also look at the request and, did the requester say anything about a time by which they needed the information or the importance of obtaining the records to the requester? So that's why it's important if you get an FOI request in, even if you're not going to be able to process it for a little bit, just take a look at it and see, because if somebody makes a request and says, hey, I've got a court date at the end of May, I really need my police report for my court date. Those are factors that, the law through this advisory opinion on promptness that the commission would like to see you consider. So look at the request. Is there any information in there that they share about why they need these records, or a sense of urgency or a timeline or anything like that? It doesn't mean that you might not be able to meet their timeline. If somebody comes in, and asks for all this stuff and says, I need it, by the end of the day, you probably can't do that, and that's okay. But just be on the lookout for those kind of things. And then on the other hand, we try to balance that with really the obligations and responsibilities of the public agency. The importance to the public of completing other agency business without losing personnel time to an FOI request, and time constraints that the agency is under to complete its other work. So that could mean that there might be a time, maybe there's a major grant application and in your department, everybody's kind of pitching in, and that's the primary focus. This grant is due in 2 weeks. We've got to get this done. That might mean that if you got an FOI request during that period, you might not have the time and resources to respond to it right away. Quite frankly, you could even tell the requester that. I think communication is really important. Obviously you have to acknowledge receipt of the request. You don't have to keep, engaging in a back and forth dialogue with the requester, but, if they are asking you to estimate the time and you feel like you can, or maybe they follow up with you and you want to tell them, hey, we're in the middle of this big grant thing right now, that's going to be done in a couple of weeks. I think we'll be a little bit freer after that. I think those communications can be really valuable in helping to avoid a complaint. One of the things I do with the commission is we have an ombudsman program. So if a complaint gets filed, somebody from our office gets assigned as a mediator to try to see if we can resolve it without a hearing. And when I review the complaints to assign the mediators, oftentimes people file a complaint because they've sent an email twice, 3, 4 times, and they haven't gotten any responses about any kind of sense of where their request is going. Maybe they got the acknowledgement, but now it's been 2 months and they haven't heard anything, and they followed up a few times. So I think if you can try to engage in a dialogue, that could be really helpful. If somebody makes a large request, you could always ask them to narrow the scope of their request. If you're ever unclear what they're asking for, I would try to clarify that right away. Don't get halfway down the request and then you're like, well, wait a second, I don't actually know if we have this stuff, or if, this is what they want. If you have questions, if you have concerns, send them an email back, pick up the phone and call them. I think those conversations can be really helpful. And honestly, like with the requester and the public agency working together, I find the request tends to be more smooth. And you may realize, maybe there's something, because you've got all this special knowledge of the records, and, they're asking for these reports. You have a conversation with them and you both may realize, hey, based on this conversation, you don't actually need all that stuff. This you've told me now because I called you what you're interested in, and that information is really going to be in this report. It's not going to be in all this other stuff that you asked for. So it might even save you time if you have a conversation and figure out the best way to handle it. So again, the standard is promptness. It's not a specific time period other than acknowledging receipt of the FOI request within 4 business days. There are exemptions and exceptions to disclosure. We touched on this already a little bit. These are exemptions that are in the FOI Act, Section 1-210. Though every exemption in the FOI Act is permissive, which means that it is a tool you can use. It's optional. So you can disclose things under that section in the FOI Act, but you don't have to. The challenge is there are other exceptions, like we talked about, other state or federal statutes, and some of those are what I like to call a shall not disclose. And that's why it's really important if you're not sure about something, maybe it's a request you've never seen before, or it's records that you feel like, gee, it seems like this is something sensitive. Those are requests, if it's not something really straightforward, where you might want to consult with the commission, consult with the law department, because there are some statutes out there, again, where it says we can't disclose certain things. One example, there's an erasure statute. If you get arrested and you go to court and your case gets nollied or dismissed, after a period of time, the police department by law cannot release that information, except to the person who was arrested. So, with police departments, for example, that's something they have to be aware of, and they have to look at the dates of the request and when did it come in, and was the case dismissed, or was it the person found not guilty, or whatever the outcome was. So there's a lot of laws that intersect with public records on both the state and federal level. And again, if you're not sure, the best thing I think to do is to try to, find somebody who can help point you in the right direction about what can be given out, what can't be given out. This is a not exhaustive list of some of the different types of exemptions that are found in the FOI Act. Some of these I have slides coming up with a little bit more detail, so I'll hold off on talking about those ones. But some of the other ones, law enforcement has a lot of exemptions. We mentioned that. Records relating to pending claims or litigation. So if there's a lawsuit that's been filed and there's discussions of a potential settlement, or there's a copy of a settlement agreement that hasn't been authorized yet, that would be something that wouldn't have to be disclosed. Test questions, scoring keys, and other examination material. This pertains to employment applications. So, for example, if you have interview questions and everybody that applies for a position, you use the same interview questions, you wouldn't have to give out those interview questions under FOI, because somebody, if they got those, then they could, potentially use that to have an advantage in the job application process. The same thing goes for, if there's other sort of scoring metrics that are used to evaluate candidates. Records related to collective bargaining strategy or negotiation. So, a contract is a public record, but the negotiating documents and different proposals that are being shared back and forth, those are things that could be exempt from disclosure. And then a couple other ones of these, I said I have some slides upcoming on. The last one on there, I'll mention that because this comes up sometimes. People ask for copies of RFPs. Oftentimes it's the people who bid on the project, they want to see maybe what the other proposals were. You don't have to release any responses to a bid solicitation or an RFP until the contract has been awarded. So once the contract has been awarded, all the information about all the bids, not just the winner, that would all become public. But if you were in negotiations to award the contract, you could say, well, we're not going to disclose any of the bids until we actually award the contract. Or if you, let's say you decide you don't like any of the proposals and you go back out a second time, then everything that came in the first time would be public at that point. So as I said, a couple of these we're going to go into a little bit more detail on. So the exemption for personnel files. People often ask about this, I think usually because we're interested, what can people learn about us, right? These are our personnel files as public employees. So information in a personnel file is only exempt from FOI if it would be an invasion of personal privacy if it were to be disclosed. And the way that the law looks at that is there's a two-part test based on the Supreme Court case. And what our Supreme Court said in that case was that for it to be an invasion of personal privacy of a public employee, the disclosure of that information needs to be highly offensive to a reasonable person, and the information needs to not pertain to a matter of public concern. So kind of like when we talked earlier about, dealing with the conduct of the public's business, matter of public concern is interpreted broadly. Essentially, if it deals with, I think the best way to explain it is if it deals with what is going on, at the workplace, somebody's performance, a complaint that was filed against an employee, salary information, the stuff that they're doing while they're at work, those are generally all going to be publicly available. Things that are probably not going to be publicly available, medical information. If you go out on FMLA and you have to submit stuff from your doctor, those types of records are generally not going to be available. If it deals with your family or your home life, we know sometimes those things can spill over a little bit into the workplace. Even something like you email your boss, hey, my kid is homesick from daycare today with an ear infection. I need to take a sick day. An email like that is probably not going to be something that would have to be disclosed because it's got medical information, about your child in there. If there is a request made for personnel records, what the law says is that if the public agency, so if the city believes that there's records in there that would be a privacy concern, they should contact the employee, and then the employee has the right to request that the records be withheld. And if they issue that, written objection to disclosure, then the city would not give the records out. If the requester wanted to pursue it, they would have to file a complaint with the commission, and that employee would have the ability to be an intervening party in that proceeding at the commission. But again, if it deals with your conduct in the workplace, even if it's bad, those are generally available. So disciplinary records, internal investigations, those are records that are usually disclosable under FOI. It's not information that we would not want to be in the newspaper. It's information that's highly offensive and does not pertain to a matter of public concern. Preliminary drafts and notes. There's an exemption for preliminary drafts and notes. And the best way, I think, to explain this is a lot of times it is like the staff work that is preceding maybe something going on the agenda of a board or commission, or somebody's asking for a report. The mayor asks for a particular report into something, and staff is working on that, and there might be drafts of that report before it's finalized and it's ready for the mayor to act on it. Those drafts would not necessarily have to be disclosed under FOI. The key thing, again, is that it's preceding decision-making. So it's still internal, it's still staff. We're still kind of evaluating the different options. And if you're withholding something as a preliminary draft, the public interest in withholding the document needs to outweigh the public interest in disclosure. So that there's some reason that we don't want to give out this preliminary draft, it's incorrect, we haven't talked to everybody yet that we need to, there's some reason that this is really not the full and complete version, and it would be misleading maybe to release the preliminary draft. You do not have to release any records if you believe disclosure would result in a safety risk. That could be a safety risk to a person, that could be a safety risk to a facility. So I said earlier that the motive of the requester doesn't really matter. This might be the one exception. If somebody makes a request for something and it's a sensitive issue, and based on their request or what they say in the request, you feel that there's a security concern. There's a process in the law. What would happen is, the city would consult with the state police, and the state police, if they believe that, disclosure would be a security risk, they would issue a letter that you could give to the requester and basically say, hey, you can't get this information because it's a safety risk to disclose it. One example on a case that I was the mediator on recently, there was a gentleman who asked for some information from the Department of Public Health about drinking water reservoirs. And there's case law and precedent on this that the commission and the courts have said, certain specific information about public drinking water reservoirs is not to be disclosed under FOI because there's concerns about, people have certain information. Could they use that to contaminate the water or whatever it may be? So that's an example where, in this case, the Department of Public Health went to the State Department of Administrative Services, and they said, no, you don't have to give that information out. And they told the requester and explained why the requester couldn't get that. So anything that you think is a safety or security risk, and this is pretty broad, may result in a safety risk. So it's not like you have to, prove that exactly what's going to happen. It could be that, hey, there's a concern here, and we have a reason to believe that there's some sort of safety issue. That's an exemption you could seek. Attorney-client privilege, any, communications with the city attorney or outside counsel, if it is, dealing with a legal matter, whether it's you're providing information, to obtain some legal advice or legal advice that is being provided to you. The key thing with attorney-client privilege is, that it's kept in confidence. We've had some cases actually where there was a memo from, a town attorney that was read, out loud during a public meeting. If you do something like that, I think that's a waiver of the privilege. So, again, it's legal communications that are not being shared really outside of, the city employees who are involved with that particular matter. This is a quite common exemption when there's requests for emails. People often make large requests for emails. This is probably the most common exemption in emails. People can't get the back and forth discussions between the mayor and the law department about, a legal interpretation of a statute or discussions about maybe a lawsuit that's pending or something like that. So attorney-client privilege is one to be aware of. Trade secrets exemption. This exemption can come up in a number of different ways. We talked earlier about RFPs. Sometimes the response to an RFP may contain things that might be a trade secret. Basically, it's information usually that you're going to receive from a business or some other third party that they consider it to be a trade secret. They take reasonable efforts to keep that information secret. They don't want their competitors to know about it, and that there's some sort of independent economic value from that not being known or accessible. Maybe it's something about their product that makes them the best in the class at what they do, and they don't want their competitors to know about that, or it's a certain method that they use, or you see, cost data, customer lists, different things. It's a trade secret to the business that they take care to not disclose. And then that means under FOI, if somebody were to request the records from you, you could sort of pass along and say, well, that's a trade secret, or the company told us that's a trade secret, so we're not going to disclose that information. The important thing with trade secrets, though, just to keep in mind, is that ultimately, you make the judgment on that. So, just because you get something in that says confidential or trade secret or whatever, doesn't automatically make it a trade secret under the law. So the key thing is that there's some kind of economic value from that not being known. They don't want their competitors to know about a certain thing about a record that they've given you. And then last but not least with records, and then we'll get into some discussion on meetings. There is a provision in the law dealing with vexatious requesters, which is basically, if you have somebody who you feel is abusing the FOI process. I share this, not because I encourage people to go run out and file these, but I just think it's important for everyone to be aware, what's the recourse if I work in a city and I feel like there's somebody who's pushing this too far, that they're abusing their rights. Well, to make a long story short, there's a process where the city can petition the commission. It's almost like the inverse of an FOI complaint. You're complaining to us that somebody has gone too far with FOI. We look at all these different factors: the volume of requests, the scope of the request, the content of the emails they're sending you. And if somebody's, if we determine somebody's abusing their rights under FOI, what can happen is we can issue an order that will basically give them like a 1-year cooling off period. You would not have to entertain any requests from that individual for a period of 1 year. We haven't done this too often. I think we've only gotten maybe less than 20 of these petitions, and I think we've only so far granted 2. There's a couple others that might go to hearings. So it's a pretty high bar, but this is kind of the legal option that's available to you if you feel like somebody is no longer seeking public records, but using FOI as a tool for harassment or abuse or something like that. And again, the people can request records for all reasons. They don't have to tell you. So it's not just volume. I think it's kind of the volume, but also the behavior. And I always tell people, if this is something that you're seriously considering, reach out, because I can give you some of the past decisions that might help you to understand kind of where the commission is on this. Because this is a newer provision. I think it was 2018 or 2019 that the law passed. So there's not a lot of cases that you can look back on, but I'd be happy to have a conversation or send you things on that if anyone has questions. Okay, so now to move on, I know we're getting close to time, so I just want to go through a couple of things on meetings and then leave a little bit of time at the end for questions. So overview of public meetings. Most important thing for you to know is what is a public meeting. And what a public meeting is either a convening or assembly of a quorum of a multi-member public agency, which is your boards or commissions, or a communication by or to a quorum. In person or by means of electronic equipment, discussing or acting upon. I'm not going to read all the things there, but basically board business. The one thing you want to be careful of with meetings is you cannot have your entire board emailing each other, texting each other, calling each other, meeting at the Dunkin' Donuts together. You cannot have those types of discussions outside of your public meetings. An email exchange among a quorum of Board of Education members, under the law, that is a Board of Education meeting. And if it's happening in the email inbox, it's not noticed to the public, so somebody could file a complaint and say that that was an unnoticed meeting. So if you're staff to a board or commission, what I always tell people is try to nip that stuff in the bud. If you send out the agenda and then everybody starts flooding in with their comments about the latest, proposal that's on there, you could say, hey, let's calm down. We need to wait until the meeting. That's probably the number one thing with meetings you want to just be aware of is, you cannot be having those discussions of board business outside of your public meetings. There's no requirement to have public comment at public meetings. That's up to boards and commissions, how they want to handle that. Everyone is allowed to attend. You can restrict who can comment. If you want to do residents only, you can do that, or ask people to identify themselves. You could do that. Anyone can photograph, record, or broadcast a public meeting, and agendas need to fairly apprise the public of what will be discussed at a public meeting. We already talked about this, email and meetings, save your back and forth debate over the issues for your public meeting. There's two main types of meetings. Again, I'm not going to go through all the different, requirements of the notices and everything, but a couple things to be aware of. If you have a special meeting, if you're at a special meeting, you cannot add new business to the agenda at a special meeting. At a regular meeting by a 2/3 vote, you can add items under new business. If you were preparing an agenda for a special meeting, I would advise you to just take off new business, because if they add new business, that would be an FOI violation. And we've had cases on that even, so just be aware of that. Agendas, go to the town clerk 24 hours before the meeting. If you have a special meeting, which is just a meeting that wasn't on your regular meeting calendar, those also need to get posted on the website. And then minutes, this is the timeline for filing. I'll talk in a second about the detail of what goes in the minutes. 7 calendar days to file your regular meeting minutes, and 7 business days to file your special meeting minutes. I don't know for the life of me why they pick business on one and calendar on the other, but you get a little bit of extra time if you're doing your special meeting minutes. There's a third type of meeting, an emergency meeting. Basically, this is an unnoticed meeting, so the bar is pretty high. It has to be something where really something that can't wait for 24 hours, because if you recall with the special meetings, it's only 24 hours notice to call a special meeting. So we're sitting here and it's, before noon on Tuesday, if we had something pop up after this meeting, you could rush, prepare an agenda, you could call a special meeting for 3 o'clock on Wednesday. So there's a lot of flexibility, but if something happened, public health emergency, major weather event, and you had to have a board meet immediately to make some kind of decision, you could have an emergency meeting, and then you would have to file minutes within 72 hours of the meeting, post them online, and they would have to contain the reason for the emergency meeting. There are carve-outs to the meeting provisions, just like there's exemptions for records, there's exemptions for meetings. So what you see up there on the screen are not considered to be meetings, no matter who's involved, even if it's a quorum of a board. If you have a personnel search committee, for a superintendent, a police chief, town manager, that personnel search committee can meet outside of FOIA. All they can do is recommend a candidate. They can't hire somebody. The hiring would have to be done by the board. Collective bargaining strategy session is not a meeting. Caucuses are not public meetings. Staff meetings are not public meetings. And there's a provision in the law about a chance or a social meeting. And what that means is it's not automatically a meeting if you have a quorum of a board, if they're not gathered for the intention of discussing board business. So, sticking with our Board of Education example, if they all want to go to the graduation, that doesn't make it a meeting of the Board of Education, but while they're up there on the stage, they should not be talking about the budget or whatever, business is going to come up at their next meeting. Minutes, I think the biggest thing with minutes to be aware of is you can keep them short. They're not meant to be a recreation of the entire meeting. The requirements, people sometimes ask, well, what do we have to have in the minutes for them to be legal? Well, really, the only thing you need for legal minutes are the record of the vote, who voted for what or for whom, who attended the meeting, the board members that were present. And if there's an executive session, you need to list who attended the executive session besides the board members. So really the content, the discussion, how much detail you put in is entirely up to the person taking the minutes. Now, certain boards probably have certain expectations of what they would like to see, and that's something that, the person taking the minutes is going to work with the board on figuring out, what level of detail is appropriate. But somebody cannot file a complaint because your minutes are too vague or that there's not enough description or something like that. If you discuss something and there's no votes taken, you could just say, there was discussion. When I was a reporter, it used to drive me crazy if there was a meeting I couldn't make it to and I get the minutes and it just says discussion of whatever. It's like, well, if you weren't at the meeting, then you don't get to hear the discussion. Today, a lot of meetings get recorded, sometimes virtually. So, there's different options for people, but the minutes is really meant to be the record of the votes plus a couple of those other details. Get the minutes in within 7 days. It's okay if they haven't been approved by the board, you have to file them. And minutes are still required even if there's a recording of a virtual meeting that has been posted. So we do minutes for every meeting. Electronic and remote meetings, there's some special rules for electronic and remote meetings. I have a handout down here that goes into a lot more detail. So I would consult that if you have a particular question, or you could ask it here or email me. A couple of things to keep in mind: recording of meetings, people ask about that. The only meetings you have to record under FOIA are if it's an online only meeting. So if, one of our city council meetings, we do it entirely online. Everyone, the public, the members, everybody was online. Nobody was here in the room. We would have to record that meeting and post it on the website within 7 days and leave it up for at least 45 days. We would still do minutes like we talked about. The other thing I want to mention too is that board members can always participate remotely at any meeting, whether it's in person, hybrid, electronic, whatever. They can always participate remotely. But it is not required to have remote participation for the public. So you can set up how you want to do your meetings. Some towns have gone back fully in person. Some towns, like here, I think you've invested in some equipment, so you might do hybrid meetings because you've got the cameras and everything. So the law doesn't say the way that you meet, that's up to you. But if you meet with electronic access, there's some additional notice requirements, basically making sure the link is out there so the public is able to log on. And then there's some other provisions too about if there's technology issues and what happens, if the Zoom goes out and those sorts of things. So again, that's covered in the, I have a copy of the document down here. We also have it on our website, our remote meetings guide. So last thing with meetings, and then we'll take questions about anything we talked about, meetings or records, executive session. So executive session, if you're not familiar, is a part of the meeting that is closed to the public. So naturally, these tend to draw a lot more scrutiny, and probably where we see the most complaints about meetings is probably with executive session. And I think with executive session, as long as you really stick to the topics that you see on the screen here, you probably won't have a lot of issues. What can we talk about in an executive session? We can talk about a personnel matter. That is, discussion of a public employee, or it could be a board member, a public officer. This could be hiring somebody, firing somebody, disciplining somebody, a health issue involving an employee. Anything like that, you can do an executive session to discuss the personnel matter. Be aware that the person being discussed can demand an open session instead. So, sometimes people are being disciplined. They might think that they're getting railroaded, and they might say, let's have this be an open hearing. If they make that request, then you would have to have that discussion in open session. You can discuss pending claims or litigation. If there's a lawsuit that's pending, you could bring the attorney into executive session to get an update. You can discuss a security matter if there's concern that public discussion would, compromise a safety and security issue. Maybe you're making some school security upgrades. You might not want to have a blow-by-blow discussion in public about all the changes that are being made. Certainly any votes need to be taken in public. So if we are voting to spend money on a security system, we have to take the vote in public to spend the money. But the board members could get a briefing and executive session on some of the specifics if they wanted to do that without letting the public know about every nuance of the new security system. You can discuss the sale or lease of property in executive session before an offer is to be put in if there's concern that publicity would affect the price. Maybe there's a piece of land that's been on the market for a couple months, and the city wants to buy it to build athletic fields or something like that. You may not want everyone in the city to know that you're about to put an offer in. So it allows for some of these preliminary discussions to be held in executive session. And then you take the vote to, authorize whoever it is, the mayor, to make an offer, or the city attorney, or whoever. So it's before the offer is being made. And then any records that are exempt from FOI, like we talked about, any of those records that were exempt, if there was a need for a board to discuss and review those documents, they could do that in an executive session. You can't vote in executive session. We already mentioned that. You need a 2/3 vote to go into executive session. So make sure that you do that and you state the reason when you're taking the vote. The board should say we're going into executive session and state the reason, and make sure you put the vote in the minutes too. When you do the agenda for a meeting where you have an executive session, it seems a little counterintuitive, but try to be specific. And the way that I explain it is the executive session conversation is privileged. The public does not get to hear what happens in executive session, but they should have an idea about the topic of what is being discussed. So to give an example, you would not want to just put pending claims or litigation on the agenda for executive session. If it's about a lawsuit, you could list the lawsuit, or you could list the topic of the litigation, discussion of the dog park lawsuit, something like that would let people know, okay, it's a lawsuit about the dog park, they could probably find it, or put the docket number if you want, if it's a case in Superior Court. If it's a security thing, don't just put security discussion, security, discussion of security upgrades to the high school or something like that, that gives people an idea. If you have an executive session, you can bring in any staff that you need to assist you, but do not create a second audience, meaning do not bring people in who are just going to sit there and are going to be observers. The people that you're bringing into the executive session, if they need to listen for a little bit to render their opinion, that's okay. If you want to run something by the town attorney and then get their thoughts, that's okay. But just don't be bringing in people who really don't need to be there, because executive session is meant to be a privilege for the board. It's an exception to the open meetings provision saying the board can go into a closed session for a very particular purpose. If you start bringing too many people into executive session, you might get a complaint from somebody who was stuck waiting out in the hallway. Well, why did those people get to go in? It didn't seem like they had any relation to this. That could be the subject of a complaint. So again, as I said, that was a lot. I know your head is probably spinning, but I'm going to go back to the beginning slide. So if anyone didn't get it, they can get my contact information. And then happy to take any questions. Let's start with the folks in the room, and then we can go to the folks online. So
first, thank you. This is very educational. In regard to your presentation, you have a summary for me you can have something like literature, or email?
Like a shorter version.
Something this would a lot of good things.
Yeah. You know what, if you send me an email, I've got some different handouts and material. Like some of the stuff down here is a little bit more summarized. Yeah, you can grab these or send me an email if you need something else. Yeah. Unfortunately, it's hard. I find it's hard to kind of do like a dummies version. I do have some stuff that's a little bit simpler that I could send you. So yeah.
And also, with regard to the minutes, we use the city of Norwalk secretarial services as we're required to. And oftentimes they'll send us the minutes 7 days after our meeting in the afternoon. So there's a time I leave a couple hours early and I'm checking the email at the end of the day. There have been a few times where I had to upload the minutes on the 8th day. And my hands are tied. I can't do anything about it.
Yeah.
Is there anything I can do to pressure the secretarial services? I've tried and I've been.
Yeah, I know from my experience, sometimes that is a challenge, trying to get the recording secretaries and getting everything done on time and all that. I mean, all I could think you could do is say, hey, this is the law, we need to follow the law. We need to have them in within 7 days. And the other thing to keep in mind is they don't have to be perfect, because you can put them on. Yeah. Yeah. So the other thing is that, if there's concerns about, whatever, they could be put onto the agenda of the next meeting and the members can discuss them and make any changes. And I think what I would say is brevity. If the issue is that they're going to the 8th day because they're trying to, record the whole meeting and listen back to the tape and get that's not what they need to do. They need to get them in within 7 days. So if it's a question of the detail versus the timeline, the law doesn't require the detail. The law does have a timeline. So I would say, just try to encourage them, do the best you can within 7 days. We can always add more later if we need to, but we have to get a version in. Now, with that case, I mean, you're probably not going to get a complaint if you get them up the next day. It's really more when I find that if the next meeting rolls around and the other meeting, that's when people start to, ask questions, what's going on? Hey, we haven't even seen the minutes from the last meeting and there's another meeting. So.
Thank you.
There's a request for information in order to have a condition that you lay out. Does it need to be identified as a FOI request?
They don't have to identify it as an FOI request, but as I said, with the research versus the records request, it has to be a request for records. So if somebody is, the list of questions, that's not really an FOI request. But if it is I would like a copy of, please send me the presentation. Like technically, if one of you went back to your computer after this and you just emailed me and said, hey, Russell, can you please email me your presentation? That's an FOI request. Now, I'm probably just going to turn around and send it right back to you. I'm not going to, we log it in and do all the things that we would normally do, but that is an FOI request. If I didn't respond back to you, you could file a complaint, even if it was just an email saying, hey, I need your presentation from today.
I have a question related to the project. Give you a little premises. We're doing a bridge, right? Project from Dairy Avenue, and the project was put out late last fall. The mayor signed a contract in January. As part of the special notes in the project, it said that the contractor had 60 days to complete the work in the notice to proceed. That notice to proceed was issued on April 4th, because obviously we didn't want to paint the whole way. The particular person who's FOI us once already is a painter who basically was looking to get a no bid contract. And when the project was put out the bid, he never bid on the contract at all. We gave him the information he wanted, we gave him the contract, all of the stuff, everything was in the package. We probably gave him 300 pages worth of documentation. He's come back now and said since then, I want to do a second supplemental submission as a FOIA request. And he's asking questions. And for example, some of the questions, he's concerned because he wants a clarification on the employee subcontractor structure, which
Yeah, I don't think that's something that you have to provide under FOI.
Right, counts of payments and change orders, which there hasn't been a payment yet done because they just finished the project yesterday.
Mhm.
It didn't start until April 6th.
Yep.
Basically, he's asking for information, and it's interesting because on the contract, there was a notary that signed the submission with a status Connecticut seal on it, but yet he didn't look at that. He says, kind of a legal explanation why there's a California notary and why it would be valid in the state of Connecticut. The California notary
Yeah,
is on the bid bond.
Yeah, and the thing of like, so those kind of things, asking you to make a determination, provide an opinion, those are things that you don't have to do in response to, it's not required under FOI. The other thing I think is important that I didn't mention earlier, the way when somebody makes a records request, you're only obligated to provide the records that you have at that time. So in this case, they just finished, there's been no payments or whatever. You're not on the hook now to provide the payments whenever they may come in. If he wants that information, he can make a request in 2 months, and there might be some stuff that, it's like when they make the request, like if there's a cutoff date and it's only everything up to that date, even if something comes in the next day, that's outside the scope of the request technically. Now you might be friendly and say, all right, well, we'll give them that thing because it seems like that's something that they would have wanted, but really you're locked into what you have the day that, you get the request. That's the record universe that you need to work off of.
And he's asking questions now related to pricing and says that it's egregious, the price is well, you can bid on it, and he says, well, I can do it for this price. Well, that would be good if you put in a bid.
Yeah, so like those kind of things, it sounds like you gave him the records and now he's continuing to follow up. So if there comes a point where you say, hey, we gave you all the records, we're not going to talk about this anymore, you could do that. If he comes back and wants more records, then you work with him to get him any other records that you might have. Yes.
So the staff of the committees, whether they're commissions or committees, and we send out the agenda. Typically what I do is I send it out to everybody, anybody who's of interest, within the city, and then also the board or committee, which obviously the entire board. And in the email, I identify the link and I say, in order to avoid a FOIA violation, please not reply all, whatever. Should I be sending out that email in separate emails to the group, like 3 and 3? And
no, I think sending the agenda is okay. I also think a one-way communication, because again, the meeting is discussion or action. So I don't think a one-way communication, would be considered a discussion. You get into a problem when people start to, jump back in. Like sometimes in a board of education, the superintendent, before they send a letter out to the school community, they might send it to the board of ed as a heads up. Here's what we're going to send out about what happened at the high school today. And they might say like, call me if you want to talk, but the board should not start responding back. So I think what you are doing is fine.
Thank you.
Anyone else in the room have questions? Yes.
I'm very concerned about security of the people that work for us, flying, pizza deliveries, that kind of stuff, that other security information.
Mhm.
Where is that one?
Okay. Well, again, there is that exemption for safety and security. So depending, if somebody's asking for certain information about an employee and there's a concern based on that, you could seek that exemption would apply. There's also.
That's all address.
So, home addresses, there's actually a statute, 1217 of the FOI Act. There are certain employees in the city based on their occupation that their home addresses are exempted. And with any record about an employee of the city, again, the standard is that invasion of personal privacy. So depending on what the record is, you could use your judgment there and you make a determination that, like you have to give out a pay stub, for example, but there might be certain information on a pay stub that you could redact if you felt that it would be, that particular piece would be an invasion of personal privacy. And then for some employees like police officers and firefighters, correction officers, those addresses can automatically come off. So if you work in payroll and somebody wants a police officer's pay stub, they can get that, but you could take out the address, from a record like that. So there was a bill last year that passed that did prohibit disclosure of home addresses of certain people who worked at the polls. And there's a process where they have to submit a written request to the registrar of voters. If you have, I would consult with Rovac on that because they might have, or you could email me and I could send you some information on it. So there is a provision around election time where some of that information can be suppressed. Is there anyone on the Zoom that has questions?
Diana Palino. Diana Palladino.
Yeah, hi. Can you hear me?
Yeah, we can hear you now.
Okay, great. So just a follow up to what Stuart was saying. So with that, would our department need to create like privacy opt-outs? If we had concerns about individuals' addresses and like personal identifying information, and create something for them.
Yes, so if you send me an email, if the both of you email me together afterwards, I could send you some more detail, but the short answer is basically what you could do, what other towns have done last election was when they were recruiting poll workers as part of their onboarding, they had them sign something that just said, you know, I do not want my information disclosed. And so if you did something like that, you know, for the upcoming election, you know, in November, if you make that part of the onboarding, then you would have all those on file. And then if somebody made the request, you could say, well, we don't have to give out. My understanding is, I think it's particular to addresses. So, you know, the names and the affiliation, you know, of the party and all that is still public, but it's just the, you know, the sort of identifying, you know, address information of the poll workers could be withheld.
Okay, and we as department heads have the ability to incorporate that into our onboarding.
Yeah, I think that's the easiest way to do it because what happened was, and I don't know if you guys got the request, but there was a request that went out, I think, after the election seeking a lot of this, and some towns hadn't done it ahead of time. And so they were rushing to try to get everyone to sign these forms. And the statute doesn't say that you can't go get the forms after the request comes in. But then it's harder because now you've got a ticking clock with the request and you're trying to round all these people up and get them to sign something. So I think if you do it in the beginning, then, you know, you've got them all from everybody. And then if you do get a request, you know, you could just say, hey, we've got these forms signed that we can't disclose the contact information.
Perfect, thank you.
If you're online and have any questions for Mr. Blair, please raise your hand electronically at this time.
We answered everyone's questions, or they want to get to lunch. Anyone else? Going once? Going twice? Nope. Well, you know, you've got my contact information. Please feel free to reach out if you have any questions. And again, you know, I'm on the phone a lot with people in your law department, so you could certainly consult with them, and if you know they can help you, and they can always reach out to me too, if you know if they need something. And the other thing I'll just make a pitch for is, you know, I do this presentation for anybody who needs it. So if you're on a board or commission, maybe you don't live in Norwalk, but you live in another town or city, you want to have me come out and do a training, just contact me, or you're part of an organization. I also like to do these for some of the bigger groups, like, you know, Register of Voters Association. I'm doing the zoning enforcement this week. So if you're part of one of those groups, professional development, they're always looking for things, and you think this would be helpful, you know, please feel free to reach out. I'm happy to travel anywhere and do it. I think it's important for people to understand. So with that being said, and no more questions, I appreciate all the time and the attention to this, and just reach out if you need anything. I'm really happy to help. Thank you.
Thank you.